Good afternoon, ladies and gentlemen. I'm going to talk about the part 3 of the Football Governance Act, which deals with the operating licenses. You can watch the other videos which deal with part 1 and 2, and as I mentioned before, I'm just going to do short videos which talk about the different parts of the Act. So, operating licenses. This is something quite new. So basically, under Article 15, a club cannot operate unless they have a provisional license or an operating license. So the provisional license allows the club to operate a relevant team, but it is not a full operating license. So there are obviously probably limitations to this. The football regulator can grant the provisional license with a view of the club later then obtaining the full license. And it basically talks about what they can do. So for example, under RT, the application for a provisional license specifies the time that it's made, the application, and that it must be accompanied by 3 things. A personal statement, so in other words, explaining who is in the club, and it has to be an explanation as well that's clear. A business plan, so that's quite interesting. I don't know how many clubs actually have a business plan, or if they do, whether it's a structured one, but anyway, they need to submit a business plan, and then any other information that may be specified under the IFR rules. So they go further to describe what is a personal statement. So they have to identify the football officers and owners, the ultimate owner, the setting out of the job title, description, role, and also senior management functions. I should mention at this point, when we use the word ultimate owner, it very much makes me think of compliance and due diligence. Right? Because if you think of the world of shipping, very often we don't know who the ultimate beneficiary owner is. So in this very particular instance, it is trying to go to the heart of who is the key decision maker for this very football club. Secondly, talking about the strategic business plan, it's a document that's supposed to talk about the proposed operations of the club, the estimate costs for the operation, how these costs are to be funded, and the sources of funding. Again, for me, these requirements are very much a due diligence compliance list. Now, how do you get granted a provisional license? Well, once you've submitted all these documents, if they are satisfied, i.e. the IF, the regulator is satisfied that to operate a relevant team, that they comply with the mandatory license conditions, then they may actually grant a license of not more than 3 years. And they'll notify the club of this. This is the provisional, by the way. And during that time, if, for instance, the club is not satisfied that this is the decision that the regulator has made, then not less than 14 days, they need to make some representations, right? The regulator will then consider whether to refuse or grant, okay? And giving reasons for it. So I want to highlight specifically, and this is Article 17.9, that the IFR must specify in the rules 3 things. The period with which it must make the decision whether to grant the club a provisional operating license or not, any circumstances that it may extend that period, and the maximum period for which the period may be extended. Personally, when I read this, I thought there probably needs a bit of clarification and elaboration on what that means, because presumably some clubs, they need to know their situation for the purposes of operating the club sooner than later. So you would hope that when they talk about extensions and maximum periods for which they could apply, that is actually clarified. If we move over to Article 18, grant of full operating license. So I would have thought for many of the football clubs, this is actually what most of them would want, to be a fully operating license or obtain that, right? So firstly, they need to apply. they need to meet the test of what it means to be a full operating license, and that would mean it has to satisfy that the club is, one, operating a relevant team, it meets the threshold, and so your next question is, well, what is the threshold? And it needs to be accompanied, that it would comply with the mandatory license conditions and, of course, oblige the duties of the club. Now, if it is not met, then the regulators must give the club notice and state why it refused the full operating license, explain the reasons and also the actions that they need to take, invite the club to make representations about the proposed action and to specify the means by which and the period with which the representations can be made. The period with which must not less than 14 days, and during that time the regulator can also consider the full license and then to see whether they've actually met the test and whether they would in essence give them that license in effect, albeit that give a provisional license. The test itself is quite interesting. So under the Article 18.7, it talks about the regulator will consider sufficient, whether the test is sufficient to enable the full license test to be met by the club. And okay, so under Article 19, there are provisions which allow for revocation or cessation of the club. So I think it's important to know that once a license is given, it's not ongoing or be it indefinite. It is actually, the regulator has the power to revoke a license. And where does that kick in? It kicks in where the club has been persistently and without reasonably excused failure to take steps to meet the test, and that there is no reasonable prospect of the test being met in relation to the club during that period. And it also talks about a club's failure. If the failure is persistent and it has occurred on a number of occasions, and for that reason it's clear that it's a pattern of behaviour or practice. So obviously when you look at that clause, you think that there has to be some measure to assess what the pattern is, and that whether that pattern results in the club not meeting the test. So then it goes on to about license conditions. So under Article 20, there's a mandatory license condition. 21 talks about discretionary license conditions, and it also details what that means. There's a full schedule and also what the operating license would entail. It also, under Article 22, talks about the scope of the powers and the very discretionary license conditions. So quite importantly, it talks in relation to debt management, liquidity requirements, restricting a club's overall expenditure, which is quite interesting, and also restricting the club's ability to accept or receive funding that is reasonably suspected to be related to serious criminal conduct. Now, I should mention, back then when I was doing a lot of debt work, that when you think about it, it's a regulator, but it has powers that are similar to a court, because it is talking about the ability to restrict the club's overall expenditure. The question I would ask is how, right? It almost borderlines a bit of insolvency management. And then of course, when it talks about restricting the club's ability, I mean, again, there's a question mark of how they would go about assessing this. So if we look at the further provision, and this is Article 22.2, is that it relates to the discretion license to a non-financial resources threshold requirement may only relate to A, internal controls, B, risk management, and C, financial reporting. Article 23 looks at the procedure for attaching or varying financial discretionary licenses, And again, it mentions about the financial requirements and the conditions there. Now, it also requires the club, for example, to explain their situation. I think if it's not made clear, there's also references to specific competitions. Let's say a football club wants to hold a particular competition, why they would want to do so. And in many ways, you could almost think of it like in terms of having the blessing of the regulator to run that. In terms of Article 24, it deals with commitments in lieu of financial discretionary license conditions. So it talks about the regulator might accept a commitment and consider the compliance with the commitment, but it would not necessarily to attach the proposed discretionary license condition made on that proposal. It also talks about, it details variations of what they would accept or not. And I guess one of the things which makes a huge difference is whereas nowadays if a club wants to run a competition, they don't have to go through any regulator. Whilst here, I think there is a level of assessment, and again, I use the word, the blessing of the regulator, so that it could be run. My question probably is, alongside this process, how efficient and expedient would it be? Because obviously there are commercial considerations of running an international game or event, and the last thing anyone will want is probably a regulator being a bottleneck, I guess, to holding an event. So that is part 3 of the Football Governance Act. The next video I'll talk about part 4, which is about owners and officers of the regulated clubs.